Morning. We're just about to start. I'm just waiting for delegates and attendees to sign in or be signed in. So we'll just give people a minute or two, if that's all right, before we start. So just 2 more seconds and then we'll get cracking. It's 11 o'clock. And welcome for those of you that have come along this morning to a review of the year. I'm delighted to once again be working with my friends at InfoTrack. A big thanks to Bronwyn, who's in charge of all things IT. And thanks to her team for setting this up today and inviting me along to drone on about issues relating to residential conveyancing that I think should be of interest to you. We are recording today's session. There are notes and slides that accompany today's presentation, and Bronwyn assures me that they will be sent out to you before we finish today. If anyone has any questions or queries, there is a chat facility, and what Bronwyn and I will do towards the end of the session is we'll filter through those comments, questions, etc. in chat and deal with any that we're able to. If you're too shy to raise questions during the presentation, or we don't have time to deal with any question that you've got or any issues that you have, feel free to drop me a note by email or drop InfoTrack a note, and I'm sure they'll get the questions to me, and I'll endeavour to answer any questions that are put across to me. Those of you that haven't had the misfortune of listening to me deal with presentations such as this in the past, my name's Ian Quayle. I have a company called IQ Legal Training, and what I do is look at the law, look at procedure, look at reform of the law, look at what's causing negligence claims, client complaints, etc., and then report my findings to practitioners. I also advise and do consultancy work for firms, looking at what is good practice, looking at what they're doing well, looking at what they can do to improve. And I work with organisations such as the Ombudsman, the Law Society, etc. Again, just looking at developments in the law, changes to the law, etc. I also work with the Land Registry and lots of other organisations. So I come at conveyancing from quite a peculiar angle in that I'm very defensive and protective of conveyancers and their practice. I'm very concerned about avoiding claims and complaints. And I'm also interested in making sure that whilst we are combining best practice, we are at the same time being as efficient as possible and making sure that we are potentially as profitable as possible as well. So let's get cracking. I think everyone's in the room that ought to be in the room. Good morning to the late arrivals. Thanks for coming along. We are recording today's session. There will be an opportunity for questions before we finish. I always mention useful websites. All of these sites, bar one, are free to access. I'll just quickly go through them. PLA website has a case law update section, which is useful. It also has lots of papers and opinions written by barristers, KCs, and the like, who specialise in property-related matters. It is a litigation website, but there's lots of stuff there that's useful for transactional property lawyers. Property Protocols is a commercial property website mainly, but there is a boundary dispute protocol which is useful in providing you with a useful reminder as to problems associated with boundary identification, assessing legal boundaries, and giving clients advice with regard to the creation of boundaries, determined boundary applications, formal boundary agreements, etc. Again, access that's free and a lot of useful material sitting there for you. Leasehold Advisory Service. Again, I always recommend to practitioners that specialise in leasehold work. There's a new guidance for leaseholders in connection with fire safety in higher risk buildings. There's, of course, an online calculator to assess premium in connection with lease extensions. And there's lots of material sitting there that is useful for you to provide clients with the bigger picture in connection with leasehold transactions. More on that in a moment or two. The Leasehold Knowledge Partnership, again, is useful. It's a political organisation, in essence, very supportive of leaseholders and very, very informative with regard to fire safety issues, fire safety measures. More on that in a moment or two as well. The RICS has a consumer guide to survey and valuations, which I always tell practitioners about. Have a look at it, provide it to clients, or refer clients to the appropriate link if you can. Association of Residential Managing Agents has a very useful leaflet on owning leasehold property, and peculiarly, given the fact that it's predominantly aimed at residential leasehold issues, there's also a very useful leaflet for clients on estate rent charges. Finally, I mentioned a site called Property Law UK. This is a monthly subscription service that does cost money that I own and contains lots of information. I think now we've got about 35 different barristers, solicitors, trainers, etc., who write on a monthly basis about things that conveyancers need to know about. If anyone's interested in that, drop me a note and I'll gladly send you a copy or tell you more details about arrangements to subscribe. So the first thing I want to talk about is what happened in May this year in CQS. And first of all, the awareness for practitioners of CQS assessment. And this is sort of a precursor, I think, to other professional bodies, etc., being more proactive with regard to assessing and determining whether or not their members are being compliant with their regulations, being compliant with their guidance and processes. So if we look at CQS, there's a number of things that I think we can take from this that I think are relevant to all firms, no matter who their regulator is. Firstly, the need to have plans and policies and to make sure that those plans and policies are kept under review. One of the things that I think we can extract from the new CQS guidance is that there is a unhappiness with regard to firms creating plans and policies and having a master file or having details of those policies and case management systems, but then not actually applying them. So if you are assessed, the assessor will come out and speak to fee owners and will ask to look at files to see that your AML policy, your property fraud policy, is actually being put into action by each fee owner, rather than asking a head of department or a fee owner what the policy is. There is also a requirement for induction processes in connection with new members of staff, including locums, etc. So if you've got temporary staff coming in, it's imperative that when they are inducted, they are aware of firms' processes, policies, and procedures. There's also a requirement for an AML risk assessment on every file, fraud risk assessment on every file, a requirement to check issues associated with SDLT and leasehold matters and dealing with lenders. We'll touch on all of those points in further detail as this morning progresses. There's a requirement for risk management, so assessment of risk. And the important point here is when we're onboarding clients, we need to determine the sort of work that we're onboarding, the type of client we're onboarding, and the risk associated with that work. So I was talking to a firm last week, and what they were saying is that their target audience in connection with onboarding residential clients are local clients or existing clients, so repeat business. And with regard to risk associated with onboarding clients of that nature, it's relatively low. But there could be transactions dealing with other parties, dealing with other conveyancers, dealing with types of property that perhaps aren't frequently encountered that could generate high risk with regard to the work that's being taken on board. So we do need to have a plan with regard to the work that we're doing. We do need to assess the work we're doing, and we need to undertake a sort of strategic risk assessment relating to that work, as well as assessing risk in connection with individual clients and individual matters. It's important that when we're undertaking risk assessment, we're monitoring data and then reviewing our risk strategies, our risk profiling in connection with the work that we're actually doing. So in CQS, there's an expectation there's an annual review. I would suggest that it's probably better to do a quarterly review with regard to the work that we're taking on, to make sure the work we're taking on is work that we're capable of doing, to make sure that we're not overloading clients and we're not exposing ourselves to risk. As far as that is concerned, if we look at conveyancing and drill down a little bit, we need to manage instructions. One of the things that I'm seeing with regard to conveyancing firms is some firms that have onboarding teams or sales teams that are dealing with initial contact from clients. And some of those teams aren't experienced conveyancers. And some of those teams are not aware of some of the risks associated with conveyancing. So their approach really is a typical sales approach of let's gather as much business as we possibly can and then transmit it to fee owners. I think it's important that where we've got onboarding staff, sales staff, etc., they have some awareness of the conveyancing process and they are able to analyze whether a transaction is high risk, low risk, or whatever, and whether the risk profile with regard to the work that we are onboarding is suitable for the firm. So last week I was talking to a firm and their onboarding team had taken on a transaction that involved an unregistered lease, the assignment of an unregistered lease, where the superior title was also unregistered. The superior title and the landlord were a limited company that had been dissolved at Companies House. And when onboarding the client, a fee, the standard firm standard fee had been suggested as being appropriate, and the client and estate agent had got it into their heads that it would be possible to complete this assignment within the next 4 weeks. Well, that's absolutely ridiculous given the circumstances. So it's important that people understand and appreciate this is an unusual transaction, pulling it out of the standard processing and letting someone have a look at it and price it and decide whether the firm wants to take on that file or not. So it's important that work types are assessed. Transactions perhaps might not meet the firm's profile. It might be appropriate that we need to think about the work that we're onboarding and who it's allocated to. And it's important that we consider the risk associated with the work that we're doing. It's also important that we assess key date monitoring and we have risk assessment with regard to that key date monitoring. Pushing on, we've got to have a conflict of interest awareness and management. And again, I don't know if you just saw something recently in the Solicitors Disciplinary Tribunal where a firm was acting on behalf of seller and buyer in connection with a transaction. Buyer was an accountant who was buying a property at a significant undervalue from a contact of the accountant. The firm was acting for both parties. They never met the seller. And it transpired, A, that the accountant was involved in money laundering, and B, the seller was a young gentleman who had severe mental issues and had a mental age of about 14 and was completely unaware that he was being hoodwinked by the buyer. In those circumstances, I think the solicitor involved in the transaction was suspended and was lucky he wasn't struck off on the basis that he had a very vulnerable client, and in acting on behalf of both seller and buyer, there was an obvious conflict of interest exacerbated by the capacity of the seller. Necessary then also to think about supervision, to think about cover, and to think about file reviews, which files we review and what we're reviewing when we look at them. And again, I repeat, it's not enough simply having policies and procedures, but the key is there evidence that those policies and procedures are being put into practice, number one, and number two, that they are being reviewed. So we're looking at the sorts of work that we're doing. We're looking at what's causing us issues with regard to file reviews. We're looking at complaints. We're looking at claims and near misses. And we're then reviewing the work that we're doing and reviewing how we deal with risk as a consequence. As far as money laundering is concerned, important that we're doing a risk assessment when we're onboarding the client. And we're determining whether or not a client or a transaction is high, low, or medium risk, and then allocating it to an appropriate person to deal with, and then making sure that we've got procedures in place for monitoring the fee earner that's dealing with the work. Again, we need to ensure that where there are money laundering issues, where we're reporting incidents relating to potential money laundering, we're assessing what the reaction of the National Crime Agency is to that reporting and whether it's necessary for us to adopt different approaches with regard to the type of work that we're onboarding or our reporting process from our money laundering reporting officer. We've got to be aware of property and mortgage fraud. And again, there's a very important point to make here. I think over 2022, we're seeing more and more firms using verification systems, processes, and programs for determining client identity and verifying client identity. And that's good news, because frequently the checks and processes that our verification platforms are using are brilliant, meaning that to an extent the heat is being taken off the fee earner with regard to manual onboarding, if I can call it that. However, I think there's a downside, and the downside is that we've got a client verification system that we're utilizing when we're onboarding clients, and therefore, sigh of relief, job done, we don't have to worry about anything else during the life of the transaction. The SRA, our professional indemnity insurers, the Law Society, CQS, most regulatory bodies are saying that is not enough. We've got to be alive to property fraud throughout the transaction. So it's not enough simply doing a file risk assessment when we're onboarding the client. We need to then have policies, practices, and procedures to keep the risk of property and mortgage fraud under review. We should be determining low, medium, and high risk files and creating different management policies for each. We need to be aware that seller identity fraud is just as prevalent as it ever has been. So where we're acting on behalf of a seller, it is absolutely essential that we're verifying client ID as we're onboarding them. Secondly, that we're also checking that when we're downloading official copies of the register, the addresses for service that are revealed in the official copies of the register are consistent with what our client has told us with regard to our client's contact details, etc. Where we're acting for buyers, we shouldn't be asking sellers' solicitors to do anything other than confirm that they've undertaken the appropriate AML checks with regard to their client. We shouldn't be asking for warranties or indeed anything else with regard to seller identity. The reason for that is we're raising it as an issue if we're asking those questions, and a seller and a seller's conveyancer properly advised is not going to provide you with warranties with regard to their client's identity. So in raising this as a problem and not getting a satisfactory response, I'm afraid that the buyer's conveyancer has dug themselves a bit of a hole. There is a way of filling that hole or extracting yourself from it in recommending to the client that where we're not sure or we're concerned about seller identity fraud, where we haven't had any form of assurance that's satisfactory from the seller's conveyancer, we can take out an insurance policy that protects our client in the event of seller identity fraud, which would, in essence, generate a total loss. I think we should be explaining to any client when we're acting on a purchase that there is risk with regard to seller identity fraud, and we need to explain to our client that the only satisfactory way of dealing with the risk is to take out an indemnity policy. But if we're going to take out an indemnity policy, the client needs to know the limit or the scope or the extent of the policy and how much will be paid out in the event of a claim being made. It's important with regard to property and mortgage fraud that we're keeping aware of what sort of fraud is out there, and also to be aware of the fact that fraudsters are sort of constantly moving and changing activity, and therefore there'll be current fraudulent activity that we're not aware of until it's publicized or until the Law Society or someone else highlights what's been encountered or the problem that's arisen. And therefore, I think we need to be constantly vigilant. For example, do we check signatures on documents? Do we have a look at things that may of themselves be of no consequence? A seller's reluctance to provide information that's being sought by a buyer, a seller providing information with regard to a property that's wrong, when the client should really know the answer to the question relatively simply and easily. Situations where clients are evasive, where clients are sort of pushing for exchange and completion without any rational reason why. Situations where clients are unusual in connection with attitude or stance. So someone was talking to me earlier this year where a client had got, during the course of a transaction that lasts 3 months, had got 8 different mobile telephone numbers. And again, you know, that's out of the ordinary. Why on earth would someone do that? Again, not of itself an indicator of fraud, but suspicious and unusual. Where there is any suspicion or unusual issues with regard to transaction, you talk to your compliance team and you get a second opinion. Hi, Zara. Yeah, what about where a seller doesn't know the answer simply because they didn't pay attention when they purchased? Yeah, not unusual, Zara, okay? But again, you know, in those circumstances, the key point here is that we challenge the client, okay? And again, you know, where a client doesn't know the answer, but you then assist the client with regard to what the response would be, and you get a client that's still sort of none the wiser relating to it, then that might be suspicious. Again, I think we've got a question, so I'll just have a look at that if I can before I move on. Just 2 ticks. Just trying to see if I can find the question. I can't. I'll come back to it. So thanks for that, Zara. Just moving on, if I may. The next thing that I want to talk about, if I can just get rid of that, that's it, is to make sure that fee earners are kept up to date with regard to policies and kept up to date as to what we're seeing out there, what the SRA is telling us with regard to fraud warnings, what the Land Registry are telling us too. CQS in the guidance warn us about the dangers associated with SDLT. Number of points to make here. Firstly, as part of a conveyancing process, we are required to advise a buyer client of the potential for SDLT liability. Secondly, it is perfectly acceptable in dealing with a complex transaction to recommend to the client that specialist advice is sought relating to SDLT. That advice could be software, could be some IT assistance, or could be seeking an opinion from a barrister or solicitor that specializes in SDLT issues. It's important that clients understand that they are liable for SDLT, that where incorrect amounts of SDLT are payable, the client has the potential to be liable for costs, interest, surcharges, etc. Important that clients understand that we are reliant on them to provide us with information that enables us to submit SDLT returns online. Our job is to tell clients about the reliefs and surcharges that are potentially available, and then ask clients for information from them to enable us to determine whether a relief or surcharge in fact applies. As far as CQS is concerned, they insist that there are file checks so that we're checking SDLT returns as against contract price and price stipulated in transfer. As I always mention to practitioners, we need to be careful about how we apportion SDLT in connection with TA10 and contract to make sure that where there is a large price being paid for carpets or curtains or other items, the client is made aware of the fact that the apportionment must reveal a reasonable price being paid for fittings, and independent valuation evidence might be necessary where the price being paid is high, or where the price that's being paid for an item has a drastic effect on SDLT. So it's necessary to undertake file checks with regard to completion statements, contract, transfer. It's important that when we're onboarding clients, clients are aware of the potential for SDLT liability and what it is likely to be. It's also important that clients are given information about what first-time buyers are, where first-time buyer relief applies, where there's a mixed-use property, what the different rates of SDLT are with regard to the commercial and residential segments of the property. And again, the good news is that there isn't an expectation that in complex transactions, we are required to ensure that our client is given all the advice necessary. There's an expectation that as a transactional property lawyer, we might be seeking specialist advice. Before I leave this slide, whenever you're dealing with SDLT and the SDLT issue is complex, make sure in your case management system or on your paper file, you have some form of explanation as to how you've arrived at a particular conclusion relating to SDLT and how you've arrived at the amount of SDLT to be paid. The reason that I encourage this is that where HMRC, if they inspect your file, can see that you've had a stab at assessing what the SDLT will be, and it's been a genuine stab at what you think the liability is, but you've got it wrong, then in essence, it's an innocent mistake. Whereas if there isn't any sort of homework, if there isn't any workings out or any detail about how you've arrived at a conclusion, there's a danger HMRC think that this is just a scheme to avoid SDLT liability, meaning your client will incur penalties and costs associated with the outstanding SDLT. If it's a genuine mistake, then you might simply be required to pay the underpayment of SDLT and to move on. If you think you've made a mistake with regard to SDLT, make sure that you notify HMRC rather than waiting for them to contact you. And be careful in some transactions, not generally applicable in most residential transactions, where it's necessary for an additional return to be submitted by the client. Again, are you going to be submitting that return? Are you going to is your retainer going to extend to that, or is that going to be the client's responsibility at a later date? We'll talk about limiting the scope of our retainer in more detail before we finish today. Leaseholds. Remember I told you about the Leasehold Advisory Service. Armour also have 2 leaflets, Buying a Leasehold Flat, 10 Things You Should Check, and Armour has a leaflet called Living in Leasehold. Both of these things, I think, provide you with the big picture in connection with the requirement of CQS. The idea to explain to clients the radical difference between freehold and leasehold ownership. CQS requires that we advise clients about term, the fact that a diminishing term means that our client is acquiring a diminishing asset. With regard to ground rent and service charge in connection with old leases, where there is a monetary ground rent, it is important that our client understands that as far as the ground rent is concerned, if there's ground rent review, our client is committing to a lease where it's potentially impossible to ascertain what the future ground rent liability will be, particularly where, for example, the ground rent doubles every 10 years, or the ground rent is connected to inflation or bank base rate, or a percentage of the market value of the flat or the apartment. Same principle applies to service charge. Your client is committing, when taking a new lease or an assignment of an old lease, to a service charge going forward, and that there isn't any fix or cap with regard to that service charge. So once again, our client is committing to an unknown or unascertained liability. The client needs to be aware of that fact. With regard to ground rent, remember, a ground rent demand is required in formal form in order for ground rent to be payable. And for service charge to be payable, the service charge has to be reasonable, and leaseholders have to be advised as to their statutory rights relating to challenging leasehold under Section 19 of the Landlord and Tenant Act 1985. With regard to CQS, we must do assessments, at least on an annual basis. And we've got to use the data, not just the collecting it. So we've got to revise policies and procedures as a consequence of the data that's been revealed. So we might have data that shows that Fiona X has had 42 complaints in connection with leasehold transactions involving calculations or miscalculations relating to apportionment. So either we, when we're onboarding clients, make sure that Fiona isn't dealing with leasehold transactions, or we provide training with regard to apportionment, or our accounts team or someone else in a supervisory role assists with regard to the supervision of the apportionment and accounts, and so that we are checking on a transaction by transaction, on a transaction basis, what's been going on, and we're helping the Fiona with regard to getting things right. I do some work for conveyancing factories from time to time, and a few years ago I did work for one large conveyancing factory, and we were looking at complaints. And the two areas that caused the highest number of complaints were where a file was being handed over from, or a transaction was being handed over from one Fiona to another. And the second highest were issues associated with apportionments relating to residential leases. And clients were going spare in connection with apportionments of relatively small amounts of money. But we were going spare on the basis that the apportionment or a final apportionment had been forgotten. And the firm was getting itself into a bit of a mess in failing to check that there were nil-nil balances on client account, for example, when files were being closed, or files were being closed with outstanding apportionments, etc. Client care we've talked about. Effective communication I'm going to deal with. I think the important point to note here is there's no such thing as a standard client. We have standard letters, standard engagement letters, standard letters with regard to scoping the retainer, standard forms of report on title, which are all brilliant, but we've got to bear in mind that clients are individuals with different attitudes to risk, different levels of experience. Remember, there's no such thing as a collective client. We're acting on behalf of individuals. There's been quite a bit of case law this year involving co-ownership, where co-owners are buying property but not singing from the same hymn sheet with regard to instructions, or not fully understanding what they're being advised to do with regard to how the legal estate or beneficial interest is being held. I will next want to talk about the retainer and scoping the retainer. There's been a number of cases this year. I don't know if you've seen this case of Spires against Withers, 2022 decision, where again, the courts were looking at the ability of a firm to scope the retainer in a commercial transaction. And what the court was saying is that in this particular case, the retainer had been scoped quite clearly. There was a clear line drawn between what the firm was going to do and what the firm was not going to do. So there's a case that's well publicized. There's some details in the notes. If you want more details, drop me a note. There was another case involving, it couldn't have been at the sort of furthest extreme, a residential purchase. And I think it was either in Plymouth or Portsmouth, where a client sued their conveyancer on the basis that the conveyancer hadn't advised them about a road scheme that was 400 yards away from the property, which would generate noise in connection with the garden. So the client was alleging that this should have been reported to her, and was also alleging that the noise, etc., impacted on the amenity value of her property. So she was claiming her loss. And the county court judge said, hang on a minute. When you were instructing solicitors to act for you in connection with the purchase, you trawl the internet to find someone that would do this conveyancing work for you as cheaply as possible. The firm that you instructed explained that they could work for you on a reduced fee, but that there would be a basic service that was provided. And the important point with regard to the basic service is that that wouldn't involve raising of additional inquiries of local authority. Again, the retainer quite clear as to what that basic service provided for. And again, the judge said the firm weren't negligent. So this idea about scoping the retainer is so important. It identifies contractual relationship and limits the potential for negligence and indeed complaints. So do have a look at when the scope of the retainer is identified with the client. It should be undertaken when the client is onboarded. Secondly, ask yourself, how robust am I with regard to the retainer in telling the client what I'm not going to do, as opposed to telling the client what I am going to do. So, for example, I'm not going to be inspecting the property. I'm going to be reliant on my buyer client inspecting the property, undertaking a reasonable inspection and reporting to me what they see during that inspection. If I can move on with regard to this, so just have a look at the retainer. It should reduce or limit potential liability in creating a contractual relationship where there is a clear and distinct line between the work to be done and the work that will not be done. Where work is to be done, it should highlight the limitations of that work. Just mentioned, we won't be inspecting the property. We're relying on you to tell us anything that you see during the inspection. That will be undertaking searches on your behalf, but there are limitations relating to those searches, namely a local search, local land charges search is out of date the moment it's done, is property specific and carries no priority. Environmental searches and reports are useful with regard to historical land use and risk. But again, it might be a situation where contaminants migrate onto a site after an environmental search and report has been undertaken. So the retainer should deal with all of these things quite clearly so that the client knows what they're getting into. On the issue of the retainer, be careful where you've been quite clear as to what you're going to do and what you're not going to do. And then as the transaction develops, you'll become embroiled in some work that is over and above the scope of your retainer, which is exactly what happened in the Spire and Withers case. And again, the important point there that we can extract from that case is that where we're taking on work in addition to what our original retainer referred to, we should extend the scope of the retainer and again clarify with the client what we're doing and not doing. More on that in a moment or two. So the retainer should be in writing. It should be agreed as soon as instructions are received. It can be implied and it could be oral, so we need to be careful. The stance of the courts is that where there is a clear retainer, where we're specifying quite clearly the line between the work that will be done and the work that won't be done, the client can't expect anything more. But watch out for vague or ambiguous wording. Watch out for conduct that exceeds the retainer. Watch out for the fact that the courts have said that it may be necessary to do work that is as a reasonable consequence of that which you've agreed to do. Let me give you an example of that. Where we are performing due diligence and undertaking searches, it is necessary to advise our client of search result. Where a search result has an impact on client objective, or where a search result is adverse to the client, then we need to tell the client about that adversity. We need to highlight to the client the risk associated with that adversity. But here's a bit of good news. We're not required to assess the scope or the extent of the risk. So again, I repeat the point. We're simply required to tell the client our search reveals an issue. And as far as that issue is concerned, that poses a risk to you with regard to your objective, or potentially could impact on the value of the property, and therefore the issue should be drawn to the attention of surveyor or valuer, for example, and it might be necessary to get a specialist report from a planning consultant, from an engineer, from a environmental consultant relating to risk. So your job, and I can show you case after case where the courts have highlighted this as a transactional property lawyer, is to draw to the client's attention risk and not to assess the extent of that risk or what that risk involves. Yeah, Zara says client objective. It's just sale or purchase. How do you do? Well, what I'll ask Zara is, well, what do you intend to do with the property? I was with a firm the other week and they were talking about pets in leasehold transactions. And they were saying, one of their questionnaires when they're onboarding clients in connection with leasehold properties is, do you have pets? And are you aware that most leases will contain issues that will limit the number of pets or may preclude the keeping of pets? And I think, Zara, we've spoken in the past, haven't we, about things like Airbnb letting. So we might, when we're engaging clients, when we're onboarding clients, when we're scoping our retainer, explain to clients in a leasehold transaction, we could have a situation where the client is made aware of this rather than us waiting for the client to volunteer it. But the important point is just saying that for a client, just simply saying to you, I'm buying it as a residential property, in my view, isn't enough. We need to think about, is it being bought as a residential property for the client and family to live in? Is it a buy-to-let investment? Is it a property that's going to be lived in by daughter or son or elderly parents, etc.? I think there's a note there for InfoTrack from Zara. Thanks for that, Zara. Okay, moving on. We need to manage and monitor the retainer. And again, look at our engagement letter and look at how we scope the retainer within it and keep it under review. We're going back to what we said about CQS to an extent, aren't we? Remember what we are needing to be aware of with regard to if additional work is undertaken. A good point that was mentioned in a forum that we had a few weeks ago was where a client, you've conducted a conveyancing transaction, the file's closed, the client rings you up about a boundary fence, about the enforceability or otherwise of a restrictive covenant or easement. There is an inherent danger in that Withers case that I mentioned earlier of providing off-the-cuff advice. And what I think we can extract from the Withers case is in circumstances where clients are contacting you after the retainer is at an end, where the client wants advice about a restrictive covenant, about their duties and obligations in connection with a wall or a fence, etc., that would involve the creation of a separate matter and the provision of advice in writing. Of course, where you don't want to go to the expense of doing that, where the client doesn't want to go to the expense of paying you, I think the only thing that you could safely do in a situation such as that is to provide the client with a copy of the report on title that you sent to them with regard to the original transaction. What should the retainer include with regard to the seller? It should involve advice relating to the quality of title and dealing with imperfections relating to the title. It should explain that we'll be drafting the contract, dealing with redemption of charges, dealing with estate agents' accounts, etc., etc. It should not include giving clients advice concerning the value of the property or whether or not the sale price is good, bad, or indifferent, and shouldn't include any advice given to the client with regard to the state and condition of the property. With regard to acting for a buyer, I think it's important that we explain what due diligence is. It's important that we explain to clients what due diligence isn't. And it's important that we explain to the client, I think in particular, about the importance of the client inspecting the property and the fact the client is bound by anything that would be revealed on a reasonable inspection, the concept of constructive notice. And it's important that we advise clients of the need and importance of obtaining a survey and valuation, the best form of survey or valuation the client can afford. And again, I'm back to that RICS Consumer Guide to Survey and Valuation to support or endorse your advice in that connection. When a client's receiving an engagement letter, a report on title, etc., we need to be careful because the client has to consent to the process. Having read a report on title or having read an engagement letter, has to consent to the client being onboarded and you're being instructed, and has to consent and approve the report on title in order for you to go forward to exchange contracts. So it's important that we understand that we need to provide information to clients, we need to provide explanation to client, and it's important that we give advice where there are issues relevant to risk. I think with reports on title, with engagement letters, the client should always be asked to acknowledge receipt of the communication, to confirm that they've read it and to confirm that they've understood it. And the client should always be asked if they have any questions or queries relating to it. And that applies with regard to written communication. It also applies to virtual meetings or face-to-face meetings with clients. After a 30-minute meeting with the client, Mr. Client, we've discussed a number of issues. Have you understood everything? Do you want me to explain anything further? Are you happy to proceed? Do you have any questions? So that we're protecting ourselves in case a client says a year, 2 years, 5 years down the line, I didn't understand, I didn't read it, I didn't gather, I didn't, my mind wasn't with it when Ian spent 30 minutes explaining co-ownership to me, for example. Again, this point about monitoring the retainer is so important as the transaction progresses. Someone asked me recently about whether or not it's possible to charge for advice relating to co-ownership, and the answer to that question is no, it isn't. You can charge for additional work that you do in connection with the preparation of a deed of trust, where a deed of trust is required, but you can't charge for advice that you're giving clients about co-ownership generally. On that issue, I was talking to someone yesterday who was explaining that they were in difficulty in a case, and the reason they were in difficulty in a case that their clients had decided that they were going to acquire the property as joint tenants in law and in equity. But the client had not explained to them that a joint tenancy can be unilaterally severed. In other words, that there isn't any requirement for common intention for severance. Simple notice of severance could be served by one on the other that would automatically create a tenancy in common in equal shares. There is a case called Singler against Brown that says in your notice of severance, if you specify how the beneficial interest is to be held going forward, and that is representative of actual contributions that have been made, the court will give effect to the fact that the beneficial interest could be held on the basis of proportions paid. That's a case called Singler against Brown. So we've talked about the purpose of the report. We've talked about effective communication. We can limit or exclude liability, but we can't adopt a sort of broad shotgun approach to limitations and exclusions in residential transactions. In commercial transactions, the position is different. But certainly we can, in our retainer, specify what we're going to do and not going to do. And in the report on title, we can reiterate or confirm that point. Someone asked me yesterday again, is it possible to scope the retainer in the report on title? And of course, the answer to that is no, because it's too late. You've already onboarded the client, the contractual relationship and tortious relationship is established when the client is onboarded. You can't amend or manipulate that relationship within the report on title. As far as due diligence is concerned, the important point here, again, that's emphasized throughout this year, there's no such thing as usual searches. Searches need to be client-specific, property-specific, and transaction-specific. There are essential searches. On the issue of essential searches, these days I'm more and more inclined to suggest that every client should be made aware that additional inquiries of local authority can be raised. I would also suggest that where a client is buying a property in a rural environment or buying a property in an urban environment where there's regeneration, current or planned for the future, that additional inquiries of local authority should be necessary. I also think, and this again sits in very neatly with the work that InfoTrack do, it's important that your client is made aware of the searches that are available via InfoTrack on the basis that the essential searches could be supported or our client's objective could be assisted by the client requesting additional searches. And remember, your task as part of your role as conveyancer is to highlight to the client searches that might be necessary given locality, given client objective. And of course, remember the position with regard to your instructions from lender as well. I was asked yesterday about climate change searches and reports, and my view currently is that we should be advising clients of their availability. I don't think we're necessarily negligent if we fail to advise the client to have one, but I think we certainly should make sure that clients are aware that they are available. I know that Stephen Troman, KC, and others disagree and argue that there is the potential for negligence in failing to advise a residential client of the need for a climate change search and report. Ryan, I'm just looking at your question. If I just deal with that in a moment, just 2 ticks. In terms of limiting the retainer after the letter of engagement, surely if the client expressly instructs you to forgo search or inquiries, for example, and agrees to sign an authority, that would be sufficient with their consent to vary. Yeah, absolutely, Ryan, I agree with that. The only point that I would mention there is, in order for a client to sign an authority or disclaimer that's binding on them. They need to know about why the searches are being required. Yeah, and a great question. Why don't we advise on the potential for Armageddon or whatever? Yeah, get Nostradamus involved too. Yeah, I take your point. I take your point. The only thing I would say, however, is this, that if we'd been talking about chancel repair liability 30 years ago, I might have been bleating on about the fact, hey, there's this thing called chancel repair liability that could potentially cause problems. And most people would have said, hey, ridiculous, we can't advise on that. It's too sort of vague or nebulous a concept. Only where someone is subject to chancel repair liability, and then lawyers start thinking, hey, I haven't given advice on that, does everyone start getting excited? Like the state rent charges, to be honest with you, or ground rent reviews that double every 20 years. That's not a new phenomenon, but people have got very excited about in the last sort of 4 or 5 years. But there've always been ground rent review provisions that double at a frequency of less than 20 years. But in the past, hey, it was just a question of we reported it to the client and, it wasn't really an issue until we start seeing claims. But I agree, the problem I have with climate change searches and reports is it's another report that we're doing for the client that I can't advise upon. And therefore, am I not just creating another potential headache for myself? Again, we're waiting for Law Society guidance relating to it. I think at the moment, the thing to do is just say to the client, it's there if you want it. Moving on, because I'm conscious of time, but great questions. Thanks for those. How do we avoid claims? I was talking to a professional indemnity insurer just earlier this month, and we were talking about negligence claims, and they were telling me something that I'd seen from another insurer earlier in the year, namely that their data reveals that historically negligence claims were arising as a result of procedural errors, failing to register at all or within priority, failing to advise clients about searches, failing to do searches, making an error with regard to missing something relating to a title. And these days, what we're seeing is more and more claims relating to a failure in connection with conveyancing soft skills, failing to communicate effectively. And remember, just as I alluded to a little earlier, communication is a two-way process. So it's all well and good sending me a 90-page report on title. But the fact is, am I going to read it? Am I going to digest it? Am I going to understand it? And do you have proof on your file that all of those things have been met? Again, your job, and this is important, is that we're identifying risk and highlighting if investigation is necessary and what that investigation could entail. It might be that we're instructed to undertake the investigative work. It might be that the client is going to do it of their own volition. Covered off that. We talked about that. Again, the key issue is you can't just simply send documentation to clients. You've got to provide clients with explanation too on all of those issues. And again, Orient Field Holdings and Bird and Bird, there's a case involving AW and Taylor Walton. All of these cases confirm the same thing. Do your search, explain to the client the search result, highlight risk, and highlight what steps can be taken with regard to the assessment or determination of that risk. Yeah, other methods of getting through to clients, Ian. Well, again, I think the key is to warn the clients about the potential for things that can go wrong, and highlighting to clients, the fact that caveat emptor applies, highlighting to the client that if the client is faced with a problem that requires litigation, the client is highly unlikely to have the appetite or the financial resources to deal with the litigation, even though our property litigators are saying you've got a valid claim. I think that's the point, really. I think the other point to note relating to case law is, again, this AW Group and Taylor Walton highlighting, spelling out the obvious and explaining the implications of search results. So here was an enforcement notice. And again, the court emphasizing you don't have to give clients detailed advice about enforcement action. You just got to tell the client there's an enforcement notice, and this is what you do to assess what the risk is relating to that enforcement notice. So we talked about the provision of information, explanation, and advice, and then getting instructions from the client as to what they want to do next. Before we finish, I want to talk about leasehold transactions. And again, leasehold transactions cause claims. Why do they cause claims? Because we don't charge enough to do a proper job with regard to the work that's expected of us. Inspection of the leasehold title, inspection of the superior title out of which the lease is derived, advice in connection with the lease and the contents of the lease, and also ancillary issues, service charge, fire risk, ground rents, management regulations, etc. I don't know whether you saw a recent decision of the SDT where a solicitor in a firm was fined £10,000 because he'd produced over 100 reports on title to clients in connection with a housing development where the developer had altered its residential leases halfway through the development, but the firm had got a standard report on title relating to the lease that hadn't been altered. The firm had not seen the change in the lease that I think it was Taylor Wimpey had introduced during the second phase of the development. So reports on title had been sent to 100 clients, in excess of 100 clients that were wrong. The matter went before the SDT, and the SDT held that the firm was subject to professional misconduct in allowing a report on title to go out that was blatantly wrong, and fined the solicitor involved £10,000 for his trouble. So a failure to do the simple things well can cause problems, just as leasehold transactions, just as with freehold transactions too. We've talked about ground rents. Remember, we've got new law that says we can't have a monetary ground rent for new leases created after the 30th of June. But that law is not retrospective. So we've got a two-tier regime. If your client's taking an assignment of an old lease, there might be a ground rent that's payable of £500 a year. Your client could, however, buy a new flat along the same street with a new developer in 2022. And as of November 2022, that lease could not have a monetary ground rent. That means, excuse me, we've got a dual scheme that potentially means the old lease is less marketable and less valuable than the new lease. There's also another issue for fee owners and practitioners. In new leases, we might see landlords being quite expansive with regard to how they deal with service charge and adding additional management fees in service charge to recoup the loss that they're sustaining with regard to an inability to charge ground rents. So Leasehold Reform Ground Rents Act became law in June this year. We've got a dual market. Formal lease extensions, I've now checked the guidance relating to this, and where you have a formal lease extension, the position is that, of course, the new ground rent has to be a peppercorn. Where you've got an agreed lease extension, the legislation now prescribes that the remaining term of the old lease, you can have a monetary ground rent, but thereafter it has to be a peppercorn. Do watch out for new service charge provisions in new leases. Building Regulations 2018 should mean that where we've got a building constructed or renovated beyond February 2019, fire safety shouldn't be an issue. And remember, an EWS1 is not a fire certificate. Be careful with your retainer with regard to high-rise buildings and fire safety issues, and be aware that frequently fire safety issues will impact on valuation in connection with lender or client, where a client is having survey or valuation. The surveyor or valuer, where possible, should be asked to comment on fire safety risks. The Building Safety Act 2020 does a number of things. It creates a building safety regulator. It creates a new regime for higher risk buildings. Higher risk buildings, buildings that are more than 18 meters in height, more than 7 stories, containing 2 or more residential units. And the building safety regime imposes duties on relevant persons, managing agents, landlords, etc., and leaseholders. Imposes a building safety regulator on the market who is there to assimilate information and data from building owners, building managers, and leaseholders with regard to building safety, not just fire safety. And the idea here is that actual incidents and near misses are submitted to the building safety regulator so that he or she can assess what's happening in the marketplace to spot the likes of the potential for Grenfell before the tragedy of Grenfell ever happens again. So building safety regulators have additional powers, namely powers concerning building regulations in higher risk buildings. So a building safety regulator will act as a building control authority. The building safety regulator has the power to issue compliance and stop notices with regard to building safety. Similar, excuse me, but not quite the same as the Housing Act 2004 and the powers of local authorities with regard to building safety. The building safety regulators' powers only relate to higher risk buildings, high-rise blocks of flats, etc. Important to understand that where you have a building that's a higher risk building, there is a concept of a principal accountable person, managing agent or landlord who is responsible for building safety, for maintaining registers relating to risks, to make sure that data relating to building safety is transmitted to leaseholders, and to liaise with the building safety regulator with regard to provision of information and receipt of information relating to building safety. There are duties imposed on residents courtesy of the 2022 Act, creating amendments to the Building Act 1984, and there's also new provisions relating to enforcement that are within the remit and power of the building safety regulator. This is important. There are amendments to the Landlord and Tenant Act 1985 that imply terms into residential long leases, requiring landlords to comply with building safety measures and requiring tenants to pay the landlord's costs associated with the provision of those measures. These are called building safety charges and are a new regime bolted onto residential leases in addition to traditional service charge. The interesting thing about the amendments to the Landlord and Tenant Act 1985 are that where a landlord falls foul of the building safety regulator and is subject to penalties or costs or charges relating to non-compliance, those costs have to be met by the landlord or the relevant person and can't be transmitted into building safety charges. Under the 85 Act as amended, there's now a requirement for building safety information to be provided by the relevant persons, landlords and managing agents to leaseholders. There is a penalty for landlords where they don't provide that information. Leaseholders are entitled to withhold service charge or administration charges. And we've got the potential for remediation orders to be made against landlords and Part 5 tenant protection for service charge costs designed to compel landlords to comply with the Act and the requirements of the building safety regulator. Building Safety Act 2020 creates building industry schemes and building liability orders relevant to construction. And the Defective Premises Act 1970 have been amended by the 2022 legislation to extend the limitation periods to enable owners and occupiers to bring claims against construction companies and contractors that have undertaken building safety work in the past. So we can skip all of that. And what I can do now is say, do you have any questions? So let's just have a look. There are a couple of questions in the Q&A. I'll just deal with those. Yeah, Sarah, first of all, says, what about lease extension? Should that be at a nil ground rent? Answer, yes, Sarah. Okay, where you are undertaking a formal lease extension, it's got to be a nil ground rent. Where it's an agreed lease extension, so it's not a formal extension, then the position is, I repeat, that during the remainder of the term, the landlord can negotiate a lease where the existing ground rent remains payable. But where beyond the point that the lease is extended, it has to be a nil ground rent. Yeah, Zara, the issue of new builds and issues with quality of build are another story, to be honest with you. And again, there's lots of stuff there and lots of information that buyers of leasehold property should be provided by developers when they're reserving plots, etc. But that's a story for another day. Other issues to talk about before we finish. Firstly, with regard to case law, what have we seen? We've seen some stark reminders about the importance of being very robust with regard to reporting on title and with regard to scoping our retainer. We've seen the courts being very protective of firms with regard to negligence, particularly where clients are paying a basic conveyancing fee, this idea of being provided with a basic service. The other thing that I think it's important for transactional property lawyers to be aware of when you start looking at property litigation, it is important to understand and appreciate that what barristers are telling me is that where you are a transactional property lawyer, it is very important to always have a think about your attitude, your stance, and your client's attitude or stance where you are negotiating or talking with the other side in connection with a problem. So one barrister in particular from Maitland Chambers was talking to me recently and saying he had a lovely case that he was quite happy to successfully defend because his client had from day one been reasonable, being open to negotiation, to being open and upfront with regard to what their position was. Whereas the party on the other side had been deceptive, had been cynical, had been secretive. And the general tenor of that behavior meant that the other side fell foul of the court at first instance and indeed a court on appeal. Selina, first of all, Zara, have you got any lists or pointers as to what we should include in retainers? Again, yeah, I have, Zara. If you drop me a note, or indeed anyone else wants to drop me a note, I can send you some pointers relating to that. I'm also going to be doing some work over the holidays, Christmas holidays, with regard to the retainer, and just having a look at that and doing some work with someone in the Law Society in that regard too. Selina, regarding risk assessments, where there's a gift from a high risk, is the source of funds are clear, and in my case, they're doctors giving a gift. Is this enough? How far do we assess the risk? Great question, Selina. Well, the point here is, if we've got a gift from a country such as Iran, then I think that clearly, as you've identified, is a potentially high risk transaction. Okay, so if you're verifying electronically with regard to source of funds and that's clear, then I think you're safe to proceed. But I think there needs to be on file an individual assessment by you as to these clients. So yeah, they're doctors. Have you acted for them before? Okay. What further information do you have? Are they resident in the UK? Are they in regular employment, etc.? I think we've got to dig a little bit further around and check, okay? And what I would do there is I'd talk to someone in my compliance team before I decided anything, Selina. Morven, thank you. Managing with regards to time, right, okay, yeah. Morven, I've just been speaking to the Land Registry last week on this very issue, right? The Land Registry in a bit of a mess at the moment, particularly with applications for first registration and sales of part, etc. Right? And the point here, Morven, I think, is I've given up advising clients as to when we're likely to get registrations dealt with by the Land Registry. Just so that you know, I'm currently working with an insurer who's looking at providing an insurance policy for applications for first registration, so that where you're acting for a buyer and you submit an application for first registration, and then your client all of a sudden has to sell because they're relocating for work purposes, etc. The idea is that we can provide an insurance policy that protects the client with regard to the situation where it's impossible to register or where there's an issue with regard to registration, hopefully thus facilitating the buyer being able to sell the property whilst it's in the process of registration. But that's something that's work in progress and we can talk about next year. Yeah, how do you deal with requisitions a year down the line? Morven, the answer to the question about should you charge, I don't think you can, right? My view would be that if requisitions are raised by the Land Registry, that is part and parcel of the registration process. And Anne-Marie, would you say a lease extension done by way of deed of variation instead of a new lease needs to have ground rent reduced for the new portion of the term? New done by way of deed of variation instead of a new lease. That's a very interesting question, Anne-Marie, and I can't give you the answer. Ping me an email and I'll try and have a look at it. Yeah, Selena, just because the lender's all right doesn't mean you are. Again, Selena, it might pay to drop me a note on that one. I'll have a look at it for you too. The email address shown on here is an email, but the better email address for you, I'll put in the chat box if I can. The email address that will get, or an email that will get to me more quickly will be ian@iqlegaltraining.com. I'll say that again, ian@iqlegaltraining.com. We're over time, and I'm conscious of everyone's time. I'll just have a look if there are more questions in the Q&A. Bronwyn, have you got any questions there that need dealing with? I'm going to deal with Marla's question, and then I think we should finish. Right. How far should we push for replies on off-plan properties? Are we allowed to raise further inquiries once mortgages in hand and developer solicitors compelled to vary the leases per lender requirements? Well, Marla, the issue with regard to inquiries is interesting, isn't it? The conveyancing protocol requires us only to raise additional inquiries where the transaction warrants it, where the provision of information from the seller requires it or where our client instructs us to do so. So the first thing with regard to your question is you should push for replies on an off-plan property. I'm not entirely sure what you mean by an off-plan property, but I think you know what you mean. You are allowed to raise further inquiries. And as far as that is concerned, where you've got a variation of the lease, then that could warrant or justify additional inquiries. So yeah, I would keep pushing on with that one. Bronwyn, right. I think we should finish at that. Again, if anyone has any questions, an email address shown on there, or the better one to send me an email to is ian@iqlegaltraining.com. Bronwyn and her team have that email address in any event. Bronwyn, have you got any questions there that you've picked up that I haven't dealt with?
Hi, yeah, Ian. There are no more questions.
Okay, fine. Brilliant.
I will send any through after this if there are any more. Just wanted to say thank you to everyone and thank you yourself for hosting the webinar. And just to let everyone know, this webinar has been recorded, so we will be sending the recording after the webinar.
Yeah, thanks, Bronwyn. Thanks, everyone, for attending. And a massive thank you to InfoTrack for inviting me along today. Thanks, everyone. Stay safe. Bye-bye.
Take care. Thanks.
Bye-bye.